So Kevin, I'd like to shift gears a little bit and talk about a situation where a borrower perceives that a lender is aggressively foreclosing on that loan. What's the best practice that the borrower can do when the loan is ultimately transferred to the special servicer?
Well, I mean, obviously, first of all, when it gets transferred to the special servicer, it's for specific trigger events,
Sure.
payment defaults, or probably the most common, borrower bankruptcy, misapplication of funds, those sorts of things, sort of bad faith acts, if you will. But a lot of what we see are borrowers actually raising their hand, knowing that they have a problem or a problem coming, and knowing that it can't be resolved at the master, and say, put it in writing. Here's what the issue is. Most borrowers will call me and ask for the advice. I said, look, be honest, be complete, lay out the situation, and ask for a transfer. So obviously when the loan comes in, the special servicer is going to look, there are no options that are not on the table within reason. One of the options always is, as a lender, is enforcing your remedies and pursuing a foreclosure. And I think most special servicers, if they're prudent, will pursue a dual track approach. You'll go ahead and file, particularly if the loan's in payment default, you've got a monetary default, you've got a clear default. You'll go ahead and initiate the foreclosure, particularly in those jurisdictions that are more difficult, more time consuming. At the same time, we'll enter into a pre-negotiation agreement with the borrower, and we'll continue to have a dialogue. And my advice to borrowers is to, take a step back, because sometimes they're so caught up in the moment or in the property that they can't sort of look at it, from a different perspective, and come to your lender, and I think this is true whether it's a special servicer or whether it's a bank or insurance company, come to your lender where you are providing a solution, that you're not part of the problem, you're a solution. And a lot of that has to do with, are you willing to commit new capital to the asset? What's the plan? Are you the right, you may have a good plan, but I may look at it and say, but I don't have confidence in you as a management company, as a leasing company. If you had JLL in there to execute on the plan, I might feel differently. So I think, you're going to explore all the options. I think it's different, as I said before. I think it's a little different today than it was 3 or 4 years ago, just because the market, particularly for better quality properties in, reasonably robust markets, there's a bid for those assets, and those assets get bid up. So unless the borrower has a plan, and as I said before, most of the time, what that plan entails is resetting the basis. So, if they're into a retail center, and the debt on that center is $200 a foot, doesn't necessarily mean that can't be a successful retail center. It just may not be successful at 200. It might be successful at 125, because then all of a sudden the leases that you can do and the TIs that you would have to put in on a net effective basis make those leases economic. So, I think the borrower, it doesn't need to be an adversarial situation. I think they need to understand that, the documents are the documents, and they say what they say, and the lender has certain remedies and rights under those documents. If we can come to a reasonable conclusion on a modification that we think gives the trust a better chance of getting out at some point down the road at a higher number than what we would get out to today, either through a note sale or an REO sale, that makes sense. But if not, if they can't be part of the solution, then our preference would be for them to sort of step aside and prepare for an orderly transition of the asset.
If you believe that they can be part of the solution and you'll sell it today at 70 cents on the dollar, if you stayed with them for a year, you get 75 cents on the dollar. Do you have a pressure you have to take the 70 today, or you could wait out that time?
No, I mean, our mandate, any special servicer's mandate under the operating documents is to maximize recovery for the trust on a net present value basis. So if the math is 70 today and 75 a year from today, I'm better off taking 70. If the math is 70 today and 85 a year from today, and I discount that back, and he's willing to put some money in to get us to that point, it may make sense. But That's one of the fallacies of holding. We sort of look at it internally that the drag, if you will, on an asset in special servicing is about 10 points. So between, the cost of advancing for P&I and the property protection advances and the fees and legal and servicing fees and everything else. So unless that asset is appreciating by more than 10 points a year, you're better off selling
10 points a year?
Yeah.
So 70,
Right. So if I've got a defaulted loan today at $10 million and there isn't cash flow coming off the property, the master servicer is going to continue to advance P&I payments to the trust as if that loan were still paid. There's going to be special servicing fees. There's going to be property protection advances for maintenance and taxes and insurance and other things, property management fees. There's going to be legal fees. And so, and that's not overly scientific. It's just sort of a general rule of thumb. I ask my, asset managers, my REO managers all the time when they say, we think we can enhance value here by holding it. My standard questions are, by how much and how long does it take?
Well, when the borrower goes back to the lender and there's an issue and they're going to talk about it, and our experience has been that they are honest and they go forward and say we're having problems, we can't make the loan payments and whatnot. What we're seeing is that while that discussion is going on, which can take a long time, I mean that conversation can take 6 months, can take 18 months, that you get to a point where the borrower says, we're done, like we want to give the keys back, and now you're waiting for that transition to happen. Mm-hmm. And the property is essentially in limbo. And so while you're in limbo, nobody wants to make a decision. So from a property manager perspective, you're going back and saying, all right, we need to invest, we need to make a capital expenditure, or we want to do a deal which is going to have TI, or the roof is leaking and we need whatever. And nobody wants to make the decision of what to do, and so then the tenants start to find out. And then there's the ricochet effect of now you've got to keep calm, keep all those tenants in place, because you've got leases that are coming up and you don't want that to be an excuse while somebody exits. So it becomes a very challenging process while that discussion is going on. And so while at the end of the 6, 12, 18-month period, while the borrower and lender may have worked it out and everybody's fine and they've got a new loan, property is still left with a certain amount of stress.
Mm-hmm.
And
it's like 10% is still
right.
You're absolutely right, and I think from our perspective, that's one of the reasons why we tend to, particularly in jurisdictions where we know it'll, take some period of time, even where it's a consensual foreclosure. I mean, there are some jurisdictions where the borrower throws up his hands and says, "I'm done. I'm willing to give it back." And just to get through the backlog in the courts, it still takes 6 months.
Get on the judge's schedule.
We would prefer at that point to have a receiver in place, because then we have some protections as the lender. We can make those advances that you or whoever the receiver is says, we need to do this, we need to spend this money, we need to protect these tenants, we need to guard against what you just described. And any lender would much rather do that through a court-ordered receivership than simply making, sort of unprotected advances that sort of puts you into a mortgagee in possession and creates some lender liability things that everybody wants to avoid. So,
I think from my perspective, what I always tell borrowers is very simple. The lender made a loan, the lender wrote the check. You now owe that check. Don't mistake for 1 second that the special servicer is tasked with recovering as much of this check as possible. And if you were in that position, you would as well.
Right.
So what can you do to add value? The one thing that we do is, before we even approach the special servicer with a hint of we need to restructure, we spend anywhere from 3 to 6 months in due diligence. Okay, we visit the property, we'll take multiple opinions on the ground from brokers, we'll say to ourselves, okay, I'm ignoring that you're my client for a second. I want to know whether you did the best job operating this property. And if not, let's find out how this property could be turned around. So that when we go into the lender, 2 things happen. Number one, we can inform the asset manager who's got 10 files, 10, 20, at times with 30 files on the table in front of him, and we can explain, here's what the issue is, okay? You're better equipped to answer the appraisal questionnaire when it comes to you, to answer certain questions about the property. So you can guide the due diligence of the special servicer. And then once you get the value on the same page, because if the special servicer thinks it's worth 20 mil and you think it's worth 10 mil, you could be the best negotiator in the world. No one's bridging that gap.
Right.
So if you can get everyone on the same page, then there's a negotiation to be had. And then the question is, okay, you're not recovering your initial investment. It's possible you will, but not on a 3 to 4 year hold. Maybe a 15-year hold, you'll eventually get back to where you need to be, but you're not recovering initial dollars. You can't underwrite what's my cash on cash for my initial investment. It's over, it's gone. And if you're looking for that, find someone to take your equity position as part of the workout with the lender.
Do you have
You're
a
not
therapist
gonna-
on council first? Like first deal with the therapist?
Sometimes it seems like it should be a component of
Right.
anything
Yeah,
else.
it's very difficult because borrowers are not, for the most part, financial guys, the operators. I always joke, you give a vacancy to a lender and you give a vacancy to a borrower or a operator, the lender puts up reserves and the operator calls a leasing broker, right? So there's different perspectives to issues. So at the end of the day, a borrower needs to recognize the position, needs to recognize the special services position. And one thing I have to compliment the special servicing community is that initially it was like, yeah, we don't care, just pay your loan, have a good day. Now there's dialogue. Since the initial wave of default where everyone was new to the process, now there's dialogue. There's the question, okay, what do you think we should do? What do you think we should do here? And ultimately it comes down to everyone's best decision for their position. But at least there's the discussion and there's the genuine desire to say, how do we make the best decision with this distressed asset?
I think I think the conversation starts. I agree with you. A lot of times we're just so far apart that it becomes pretty clear that you're not going to bridge the gap. So then you sort of shift the conversation over to how do we prepare for an orderly transition of the asset. Are you going to consent to a receiver? Are you going to provide a deed in lieu? Are you going to stipulate to the foreclosure, whatever it is? But I think what we try to do, particularly if the borrower is sincere about pursuing a mod, is let's both agree to something that Ira said earlier. Let's both agree on what that property is worth today as is. And that's where we're, as the special servicer, we're going to start from there. If we're going to talk about a modification, we're going to size the A note that we expect to recover at that number. And then it's up to the borrower to believe that there's upside and willing to put their money behind that belief in the upside, and that they'll realize something, for it down the road. And we may at that point consider subordinating the balance of our debt to that new money in some sort of return on that money. But it's got to be accretive.
I wonder if an interesting tweak on that. If you both agree that today it's worth $10 million, that's if everyone agreed and you could sell it. But if you're fighting with the borrower, it goes to your 10% rule, and it's going to do, it's worth $10 million. But if you have to fight him, no one in a fight, it's worth only $9 million. So you're both agreeing it's at 10, you're both agreeing it's at 9, and building up from 9. It's somewhere in the middle.
One thing lenders and borrowers don't often do is agree. So, you come at it from
The
different.
only time they agree is on the going in.
Yeah.
No, they always think they'll get enough.
You're coming at it from a different perspective, but that factors into it. We looked at it, we'll look at it too. And the other thing to keep in mind is, we'll look at, what could we realize on that asset if we were to take it to market and sell it as a note? How long would it take us to foreclose? And then what, if we sold it immediately, Zaria, what's it worth? If we held it for a while and stabilized it, what would it be? And all of that sort of goes into our analysis and gets discounted back, and so that's taken into account. I think obviously our preference would be if we can't come to an agreement on value that we don't end up in a protracted litigation. But
I think just
that's
to address
not
that, you'll have a situation where today's value would be X, but what the lender wants is greater than X because they look at it on a net present value basis if they were to hold it and turn around the property. So that 10% rule is great, but you're taking that off of X. You need to look at X plus the upside
Correct.
for what the lender is looking at, because let's face facts. You took a loan, you put the lender in a senior position. They need to exercise their rights. And that's really, the most important thing we do is tell the borrower up front, you're in for a fight, and here is your only hope to make something work, is to take the approach where the lender and the borrower agree on a neighborhood when it comes to value. And the agreement is never vocalized. But you're there when you start negotiating, okay, here's where we could do a mod, or here's basically...
You're not signing it's $9.2 million.
No, there's no stipulation up front, consideration, anything like that.
I think one of the other things, and I would like to believe this is true, But if you look at it, like we also acquire new issue B pieces. So we will analyze, and we do diligence for other buyers of B pieces, and so we'll do diligence on the loans. And new lenders will, before they make a loan, they'll give the borrower a questionnaire and how many workouts have you had, and how many deed and liens, and how many foreclosures, and how many bankruptcies, and all these things. And of course, we've got, a long track record of dealing with things, so we recognize a lot of the sponsors. And so I'm not necessarily troubled by someone who has had foreclosures or deed and liens, on their credit record. I mean, that's sort of the world of non-recourse lending. As somebody put it the other day, I mean, borrowers view these not as 10-year loans, but as, 10-year put options. At any time, in the course of the 10 years, if they want to, they can just put it back to the lender. What I'm more concerned about is how, in those situations where there was a problem, how the borrower has behaved. And if it's a borrower that unnecessarily took the lender into bankruptcy or threatened bankruptcy or prolonged litigation that
Play
caused...
nice in the sandbox.
Exactly. I mean, the reality is, and you can start at the biggest public REITs in the country who have given multiple properties back. It doesn't mean that, the lending community is going to stop lending to those companies.
I get pushback all the time, and I'm curious to hear your feedback. We're going to get dinged if we do a workout. I said, how about if you give the property back? Yeah, that too. We'll just, cover it and refinance. And then the time comes when it comes time to actually write the check, and then they default or they don't default. And certainly you want to pay off your loan, but too often we get, we've never defaulted on a loan in our life, so we don't want to even approach to talk to the lender. Obviously, no default, no workout is better than a default or a workout. But sort of they feel that it's game over if you ever default to give back a property. And unfortunately, I think it costs borrowers because they don't come to the table early enough, and it costs lenders sometimes because the borrowers don't come to the table early enough where you could actually save a property. So I'm just, the concept of your life is over, I think, is sort of a bit of a misnomer.
Yeah, I know. I think it's an exaggeration. I mean, wearing my lender's hat, I like the people that say, I've never defaulted, I'm not going to default, I'm just going to keep paying and I'll pay you off. That's great, and that would be our preference on every loan, but that's not a, practical outcome. So, and I don't think the capital markets today necessarily penalize borrowers if they've had workouts. I mean, I think they'll look a little further than just simply, I had, 5 workouts in the last 3 years and here's where they were. In some cases, the market, the market completely collapsed under them. Somebody made what they thought was a great loan, borrower thought he had a great property to a great credit tenant, and then 5-6 years into the process, that tenant filed bankruptcy, nobody saw that coming. Stuff happens. I mean, and we recognize that, but like I said, it's more about, how you conduct yourself.
I was by a meeting with introduced a very large developer. It's a 3-generation family real estate. And the president of the bank asked him, so have you ever had defaults? He says, I've been around this long, of course, but I lived up to every letter of the law, of the agreements, and the spirit of it. In every situation I went through. And they kept doing business. And after I turned to the president of the company to ask his opinion, he goes, I actually like this situation better because he has credit. He was tested, and we saw how he reacted.
Right.
Because I'm more nervous about this new person who comes in, is buying this real estate, never had an issue.
Right.
What's going to happen then?
Right.